Good evening, everyone. It's my great pleasure to welcome all of you to our today's lecture on evidence law in times of the big data revolution. It's my special pleasure to introduce Liat Levanon, who's our speaker for tonight. She is now at the Dickson Poon, I think, I hope I remember Dickson Poon School of Law at King's College in London. And I've heard she's been very recently promoted to become a lecturer. She's a reader, from the senior lecturer to the reader position in August. Liat Levanon did her PhD on a topic which is very familiar to what we are doing here, sexual offense law. And she's written, so evidently one of her research interests is sexual offense law. She then has worked as a researcher in several different places, at Zurich University as a postdoctoral researcher from 2008 to 2010, and then at the Israel Democracy Institute in Jerusalem until 2012, and then returned back to England and became a lecturer in London, and finally then professor at Cornell, and then moving on to King's College, where she's now. Her research fields and her publications are, as I already mentioned, sexual offense law, also quite a lot on another of my favorite topics, criminal law theory, specifically the question, why should we punish, theories of punishment. She has published a couple of articles in that field as well. And more recently, actually it's also quite a while ago, but there's definitely a clear Schwerpunkt in the area of evidence law, and the most recent important publication in that respect is a book which came out last year, if I remember correctly, on evidence, respect, and truth. And today we will hear, and she will connect the issue of evidence with big data revolution. So I'm really curious to hear what you will tell us about the subject. Please.
Okay, thank you. Thank you very much for the invitation, for the introduction, and to all of you for coming to here. The problem that I have been thinking about in the past few years really is the problem of algorithmic decision making in law. Basically, why shouldn't we allow an algorithm to do legal fact finding for us, assuming at least that someday algorithms will be able to do that more accurately than human beings can. Now, there are many reasons why not, why perhaps not, and I do not want to engage with all of them. For me as an evidence law theorist, what interests me is the idea that, that algorithms use the wrong kind of evidence. They use what we call naked statistical evidence, and this is not evidence that provides good basis for legal judgments. Now, when I say naked statistical evidence, what I mean is, let us assume that we know that all of us here except two like chocolate. This means that statistically, each and every one of us is very highly likely to be a chocolate lover. And this is the naked statistical piece of evidence that can be fed into an algorithm that can use it in order to make decisions about each and every one of us. And what I will try to argue is that this kind of evidence is not evidence that provides good foundation for liability judgments in criminal law specifically, in the law more generally. My attempt here is one of several evidence law scholars have been grappling with this question for quite a while now. There are many suggestions out there. We all kind of feel that we are nearly there, but not entirely. We can talk about other suggestions later if you wish. Now, we can start the discussion perhaps by locating it in its wider context. So the question of algorithmic decision-making is, of course, not limited to the legal realm. Technology is advancing in a way that allows us to gather huge amounts of information that would open the door for algorithmic decision-making in a very wide range of contexts. And in many contexts, this is fantastic news. If an algorithm can diagnose cancer much better, much earlier than even the best doctors can, fantastic news for patients, okay? Now, we need to be careful, of course. We don't want to replicate the British government's failure when it was trying to determine students' A-level grades algorithmically during the COVID-19 revolution. It was a big fiasco. But as long as we gather the right kind of information and make use of this information appropriately, then why not really? We would benefit in accuracy in such a wide range of contexts. Now, the law in general and the criminal law in particular cannot hide from those developments. And indeed, there are arguments in the literature, and they are descriptive and normative. The descriptive argument is that the law is already algorithmic to a high extent. So the decisions that the law makes are made in a way that resembles very much algorithmic kind of reasoning. And the normative argument is that this is good, that this is what we should be doing more of it, and to the extent that we can ask AI to do it for us more accurately, then fantastic. It would be doing exactly the same thing that we have been doing for so long, only better. My argument is mainly concerns the normative claim that we should or should not, I would argue, do that. But I would like to say a few words about the descriptive claim, especially because, at least in the English-speaking world, it is being pushed very strongly recently by various academics from various disciplines. So what have we got there descriptively? We've got Bayesians, people who work with Bayes' theorem in order to calculate the probability that a certain proposition is true given a certain piece of evidence. And they are telling us that all legal evidence is probabilistic or naked statistical anyway. What do they mean by that? They mean that when we say, for example, that this first-hand testimony is reliable, really what we are saying is that the vast majority of first-hand testimonies that look more or less like this particular first-hand testimony are reliable, and from this we can infer that this testimony is also reliable, which is an algorithmic way of thinking about the evidence. Now, I think that it's an argument that is out there. I don't think that it is particularly convincing. I think that it doesn't give enough weight to legal practice as it really is. It is true that every piece of evidence can be accounted for in statistical terms, can be accounted for probabilistically, but it is also true, I think, that this is not what the law does. When we reason about eyewitness testimony, this is not the way in which we reason. And there are other ways to reason about evidence, and they are valid ways to reason about evidence, and we should attend to the fact that this is just not what we do in the law. But a more moderate claim is recently being pushed very strongly by Professor Ron Allen from Northwestern and Michael Pardo, and what they are trying to suggest is that the law it is not as if all the evidence that the law engages with are probabilistic, but the law is very friendly to probabilistic ways of reasoning and to statistical evidence. And they are saying forensic evidence. Forensic evidence, that's bread and butter for criminal law. Many types of forensic evidence are analyzed by forensic scientists using probabilistic methods and are introduced in the courtroom in exactly this way. and the courts are very happy about that. There are other types of, not all forensic evidence are introduced in this manner, but there are other types of forensic evidence that are at least implicitly probabilistic. And there are also non-forensic legal evidence that is at least closely associated with statistical data. And we can think here about what we call bad character evidence, evidence of prior misconduct or prior convictions. And here it is quite, we know in the law that what we do is to say, okay, if a person committed an offense, a similar offense over the year before the person has been charged, then we know from our statistical data about recidivism that this person is very likely to have repeated and therefore more likely to have committed the offense at issue. So Allen and Podor are saying we are already, that the law is very friendly to statistics anyway, and to say that the law has aversion from statistical, from finding, making legal, making factual findings on statistics, that's incorrect, not valid. I would like to say a few words about that. So I think that to say that the law is friendly to statistics is not at all the same as to say that the law is willing to decide on and solely on statistics, okay? So it is correct that we admit such evidence into the courtroom with a few exceptions, and only a few exceptions. We do not see liability judgments made only on such evidence. The exception, perhaps, is DNA evidence in the United States, okay? And to be honest, I'm not sure how things stand here in Germany. I can tell you that in the UK, courts were not, until very recently, there is this one decision that kind of undermines this, but until very recently, courts were not deciding liability solely on DNA evidence. That gives even an extremely high probability of identification. So this is one exception, but overall, if we set this aside, we do not see judgments on statistics alone, on probabilities alone. We also do not see the prosecution, the UK CPS, the Crown Prosecution Services, charging based only on statistics. So they have access to a lot of information about people, and they could have gathered much more information had they wanted to, in a way that would allow them to say, well, statistically, we think that you are very highly likely to have committed this offense yesterday. They don't do that. The only cases where we see, and therefore those cases do not even reach the court. There is no, the court does not need to deal with a situation where all that the court has is statistics. The only situations where this happens is where the prosecution introduces some statistical evidence, some non-statistical evidence. All the non-statistical evidence collapses. It proves unreliable during trial. And then the court needs to decide what to do. It's extremely rare that it happens. And I can tell you that it happened a couple of years ago in Israel, that it reached the Israeli Supreme Court. Justice Alex Stein, who taught me everything that I know about evidence law back when I was a student at the Hebrew University and he was teaching there, very familiar with this problem, gave all the literature in the judgment and said, what I can see is that all I'm left with is the very high probability that the defendant committed a crime. I'm not deciding liability based on this alone. This is impossible. The last thing that I want to say about this is that regardless of what really is happening, I'm very happy to think like a philosopher in this context and to make thought experiments, and philosophers have been doing just that. And there are many thought experiments where we ask ourselves, would we decide liability in those conditions? And the answer is really no. There is, and the example that I will use here, because this is the typical example that they have been using in the criminal law context, is called rodeo stadium. And in rodeo stadium, people come to watch the rodeo. There are 1,000 people coming to watch the rodeo. 950, we know, gate crushed. 50 paid for the ticket. We could potentially pick random members of the audience. There is a probability of 95% that each of them did not pay for their ticket. We could charge them for that? Would we convict them? I don't know what you think. I wouldn't. I've been asking my students year after year, and the outcomes are always the same. There is always one student. There is always the one who would convict, but normally no. So this is about the descriptive claim, and I hope that we agree that courts don't or wouldn't decide liability on statistics alone. But as I said, the heart of my argument is normative. So let's talk about the normative arguments, about different way in which it has been constructed, and about how we can push back, how I am trying to push back against it. So Bayesians are telling us in very simple terms, well, we should be deciding liability or making factual findings at least algorithmically, because this is the most accurate way of making them. And the law is a practical discipline, and therefore the law should be very interested in maximizing accuracy. When we maximize accuracy with the help of statistics, we maximize value. We maximize value in the specific case, and we maximize value across the board in the system. And this is what we want to be doing. Even more traditional criminal lawyers have proposed more moderate normative proposals in this spirit. And Vincent Chayo has advanced into very appealing articles the idea that we should be using algorithmic decision-making to guide us when we sentence. And what he says is, well, I am looking at sentencing judgments in North America, and what I see is disturbing. There are very often cases that look to me very similar, and the sentences are very different. And we need to deal with that because this is inappropriate. And my suggestion is that we take AI, we feed the AI with all the cases that we have so far in the jurisdiction. The AI would be able to identify which factors push towards which sentence. And then the AI, we will feed the data of our specific case. The AI will tell us that the appropriate sentence should be this or that. Now, this is quite appealing because I've been thinking, well, what would have happened had I gone to, I don't know, to the United States and been asked to sentence? What would I do? Even if I could read the principles or the sentencing guidelines, whatever they are. So I want to read as many cases as I can in order to be familiar with what has been done before I make my, and then I would make my judgment based on what I have read. Now, my mental capacities, my time, etc., are limited. AI can do that much more effectively. We can feed much more information. We will get a much better picture. Why not? I don't know, but I'm trying to push against it anyway. No, it feels, the thing is, the answer is that, okay, Chayo is saying only sentencing. Why only sentencing? Why not liability judgments? It works the same way. Chayo is saying only as an advice in the meantime, and he keeps on saying in the meantime. But the in the meantime is exactly because we don't trust the algorithm enough yet. But one day we will have an algorithm that we can trust. And then what? We will let the algorithm decide sentences. So my task is to try to push back against the proposals that the law should utilize algorithmic decision-making tools. And there are different attempts to push back. And there is one theme that philosophers have highlighted as they have been trying to push back, and that seems to be recurring and deep. And it has to do with the correlation between legal practice and epistemic practice. And the idea is that the aversion from statistics is not something that we find only in the law, not something that we find only in legal practice. We find the same aversion from statistics when we make epistemic judgments about what we know and what we don't know. And the idea is that when all that we have is statistical evidence, that indicates that a certain proposition is true, we do not yet know that this proposition is true. Okay? And the example that epistemologists like to give is the lottery example. I bought a lottery ticket that I know has a chance of 1 to 1 million to win. Based on this figure alone, I do not yet know that my ticket has lost. Okay? But if I read the winning number in the local newspaper, well, there is a 1 to 500,000 likelihood of a typo or an error, and I see that the reported number, the winning number, is not my number. At this point, I already know that I did not win, even though the likelihood of error is higher. Okay? What is the conclusion? The conclusion is that some pieces of evidence, some types of evidence are what we call knowledge generating, the newspaper. Some pieces of evidence are not knowledge generating. Statistical evidence is not knowledge generating. And then philosophers are telling us, okay, look what is happening here. The law, which is a practical discipline that should be interested in accuracy, suddenly says goodbye to practical considerations and becomes interested in epistemic considerations. The law suddenly seems to care about increasing human knowledge. Okay, where does this come from? Now, this point has been was made, I must say, implicitly already in the 70s by Jonathan Cohen in his book Probable, and it was made. It then boomed again following a very explicit and well-argued suggestion by Enoch Spector, David Spector, and Sally Fisher, Philosophy and Public Affairs. Once we have identified this correlation between law and knowledge, we need to start considering why the law should care about knowledge at all. We need to ask ourselves whether we can construct an argument according to which, yeah, that's a good idea, that the law should care about knowledge. And there are two ways to do that. One way is to try to argue that the law should care directly about knowledge, or at least about some epistemic considerations. And the other way is to suggest that the law should care about knowledge indirectly. And what do I mean by that? I mean that the law cares about practical considerations, only about practical considerations. But practical considerations are not divorced from epistemic considerations. So what legal practice is showing us is that there might be some deeper connection between practical normativity, which is the main interest of the law, and epistemic normativity, between how we reason about what to do and how we reason about what we know. Now, our task is to try to unpack this connection, and this is the intellectual context of my own contribution to this conversation. I've been trying to understand the connection between epistemic and practical normativity, and I do it in order to defend the claim that we cannot make legal judgments on statistical evidence that cannot generate knowledge. And the first step is found in my book, and this is the step that I will show with you today. And what I will try to show is that when we make liability judgments in specific cases, and we don't know the facts of these cases, don't have proper knowledge in the epistemological sense of it, our judgments are disrespectful of defendants. So respect, which is a practical concept that the law is interested in naturally, has an epistemic condition built into it. We must know in order to respect. Now, I will open brackets here. Maybe it's worthwhile saying that I'm currently working on further abstracting this argument, and I will largely spare you this misery, and I will only note briefly that the idea is that it's not only reasons of respect that require knowledge. All reasons require knowledge if they are to be appropriately responded to. It is part of the nature of reasons that they firstly are knowable And secondly, that to be responded to appropriately, we need to know them. And I think that this, and I used mainly Joseph Raz's account of reasons in order to construct this argument. And I think that this kind of really goes to the bottom of things, to the bottom of the relation between practical and epistemic normativity. And this is why whenever we make practical judgment, we care in some way about knowledge, we're interested in knowledge. But for today, we can set this more abstract claim aside, and we can focus only on reasons of respect. And once we have figured out what is going on in the realm of respect, the abstraction is, I will not say straightforward, but it follows in a way. Okay, so I think, or I at least hope, that there is something intuitive in the suggestion that to respect we need to know. If I think back at what happened in the United Kingdom when there were huge demonstrations by students whose A-level final secondary school grades were decided algorithmically, they were holding signs saying, "Judge me by my work, not by my postcode," because the algorithm, the way that it was constructed, it partly or quite massively took account of past results in the child's school, the child's area of living, etc., etc. And I think that what they were saying is, you know nothing about my work, you know nothing about my effort, you're deciding based on where I live, you're disrespecting me. They were angry, okay, they were hurt. So I hope that it's intuitive that there is an element of disrespect here, but as an argument, it is also very empty and still and very superficial. You're disrespecting me. That's really something that can be invoked day in, day out, without more. It is just an indication that the person is hurt for some reason, and not each time that we are hurt, not even each time that we are feeling like we have been disrespected, we have in fact been disrespected. So what I need to do now is to look at the literature on respect and to try to trace an account of respect that would explain why to respect we need to know. And this is what I will try to do in the coming few minutes. I will try to outline an account of respect, and then I will try to show how we can learn from it that to respect we need to know. So I will be taking respect as respect for persons as deontic morality's fundamental concept, but this is only a tentative assumption. Please note that for my purposes, it is enough that respect is a consideration that the law is interested in, not more than that. And I will understand respect for persons the way Joseph Raz has. And what Raz is suggesting to us is that respect for persons is an open and positive disposition towards human value, or a state where we at least don't block ourselves from maybe later engaging appropriately with human value the way human value calls upon us to do. Now, what does respect consist of? Raz is saying that respect consists primarily in regarding persons. I will say it slowly because this one, regarding persons only in ways that are consistent with the human value in our thoughts, in our words, and in our symbolic action, whenever we engage this person at all. Okay, so it will become important, this idea that we need to regard people consistently with the human value. So that please remember this in the back of your minds. Now, I would like to alert you to some features of this very short premise. Firstly, respect for persons seems to take place mainly in our thoughts. Okay, this is what Raz is telling us. It's something very preliminary before even we act. It is how we think about the people around us, and in our thoughts as they are translated into words. I would like to also mention, and this is not essential for my argument, but I'm really struck by it, so I will mention it. That Raz is, when Raz says thoughts, he says he means everything that goes on in our minds. So he says beliefs, which are relevant for my arguments, but he also says attitudes, hopes, imaginations, fantasies, everything that goes on between our ears needs to be consistent with human value when we engage with persons, okay? It's a very brave thing to suggest. What about action? So Rance limits what he says to what he calls symbolic action. Symbolic action would be action that kind of has communicates in a way, has the social meanings of respect, and he says this is socially determined or mostly socially determined. But please note that it does not mean that all of our actions are excluded from being evaluated as respectful or disrespectful, because all our actions are guided by our thoughts. And whenever an action is guided by the thought that the person that we engage with is a means only or does not merit respect, then we are disrespecting that person, okay? So it does apply also to action via thoughts. What merits respect? So human value merits respect, and human value arises from some basic human characteristics. And in Raz's largely Kantian account, it is the human capacity to be valuers, okay? So, and this has an implication. What we respect about people is the ability to be valuers. And it means that human value resides not only in the persons themselves, but it spills over to people's valuable endeavors, okay? So human relationships, human works, spontaneous expressions, they are all valuable because of different features that they possess. But one of the explanations of the value is that they are ways in which valuers, people as valuers, exhaust their capacity by engaging with value and with what they deem and constitute as valuable. So all these human endeavors call for respect. People call for respect, and human endeavors also call for respect based on human value. Now, I will say a couple of words. If I have time, I will say more later, but for now, I will say a couple of words about the scope of this account of respect, because if you have been following me so far, then you might be suspecting that this is really very demanding, too demanding an account of respect, which makes it a suspicious account of respect. Respect makes demands on our thoughts about persons and about human endeavors, and because our thoughts underlie virtually all our engagements with persons in words, in actions, then all those engagements are also implicated. It means that there is potential to trace disrespect everywhere. Everywhere we turn, we will find some disrespect, and this is not particularly desirable. So I would like to note, and this is yet another, I think, important and interesting feature of Raz's account, that when Raz speaks of reasons of respect, he does not speak about duties of respect, and he makes it very clear, okay? So he said there are many reasons of respect. There are different types, different strengths. Some of them might constitute duties. For example, the idea that we have to respect in action is more maybe a better candidate for duty giving than mere respect in thought. The idea that we have to respect people's bodies is maybe a better candidate for duty giving than the idea that we need to respect people's, I don't know, work or definitely property engagements or whatever. So not everything is a duty, it's just a reason. And even amongst those reasons of respect that are not duty giving, there would be stronger ones and weaker ones, and they will feature differently in different situations. So this is one thing that I would like to note. The other thing that I would like to note is that we can also remember that given the force of human weakness in this regard, disrespect probably is often excusable. So that we all too often disrespect others is nothing but an indication that it's very difficult to truly respect everyone all the time. and we follow. And there is a reason to excuse us in a wide range of circumstances. That's it about respect from me for now, maybe later a little bit more. So we have an outline of an account of respect, and what I will try to show you now is that if we take what Russ says seriously, then we will reach the conclusion that in order to respect, we need to know. That respect is based firstly on knowledge of reasons of respect. We need to know the reasons, and therefore we also need to know the facts that give rise to those reasons. And the argument is basically that knowledge of the facts of specific cases is a good proxy for engagement that is consistent with human value. Normally, without knowledge of specific facts, we would fail to engage consistently with human value and therefore fail to respect persons. Now, to say this, I need to unfortunately say a few words about knowledge. So I will do it. There is a lot to be said about knowledge. I haven't said anything about knowledge so far. I will do it very briefly, and I will only highlight the feature that is important for me. So the important point for me is that knowledge of a proposition requires the ability to recognize alterations in this proposition. What do I mean? Think about lottery, the lottery example that I mentioned earlier. So, well, I don't know that my ticket hasn't won based only on the very low probability that it has won. What is happening here is that my evidence is the probability, okay? My ticket has actually lost. I can believe based on my evidence that my ticket has lost, but imagine what would have happened had my ticket won. I would still have only the probability. The probability would still be the same. I would still believe that I have lost, okay? So there is an alteration in reality, but I do not respond to it. I cannot respond to it based on, with my beliefs, based on the evidence. When this is the state of affairs, there is no knowledge. This is what we need to know about knowledge, okay? And different accounts of knowledge capture this in different ways. The account that captures this most explicitly is Robert Nozick's account of knowledge that says that our belief, in order for our belief to qualify as knowledge, the belief needs to be sensitive or truth-tracking, which is exactly this. It needs to be able to respond to alterations in the specific facts. So we have an account of respect. We have sort of an account of knowledge, something that we know about knowledge. And with this in mind, please assume for a moment that I engage with a person's conduct in a certain way which I think is respectful, okay? But assume also that I don't have knowledge. I don't have knowledge of the facts of this conduct, and I also do not have knowledge of the reasons to engage the way that I do. So my thoughts are based only on probabilities, and therefore I'm not capable of recognizing alterations in the conduct, okay? And therefore also I'm not capable of recognizing alterations in the reasons that exist to engage the way I do. In such conditions, it essentially remains possible for me that in the specific case that I am engaging with, there are in fact no reasons to engage the way that I do, and there are reasons to engage differently. I just can't recognize them, okay, because of the kind of evidence that I've got. And when I continue to engage, I essentially concede that if such is the case, if there are reasons to engage differently, then tough luck, okay? Then we should disregard those reasons, and we should disregard the value that gives rise to those reasons. And this concession that I must hold when I engage based on statistics is not consistent with value. The value of the conduct which is at least in part given by human value, doesn't allow for such a concession. Value calls on us to respond to it appropriately. Tough luck is not appropriate. And let's demonstrate this in the context of legal judgment. So if I'm a legal decision maker and I am convicting someone and I do not know, don't have knowledge, properly speaking, of the reasons not to acquit my defendant, then it remains possible for me that there are no such reasons and that in fact there are reasons to acquit. And I concede that if there are such reasons to acquit, then, as I said, tough luck. They and the human value that underlies them ought to be disregarded. And this is inconsistent with the human value of the defendant, and it is disrespectful of the defendant. Okay, so engaging with human value, with human conduct, respectfully or consistently with human value, presumes and requires knowledge of the facts of this specific conduct. When we know, we don't make tough luck, disrespectful concessions in our thoughts. And this is what I have been trying to show. Now, I could, but I wouldn't spend a few more minutes refining further the argument, because there are some niceties about knowledge, and maybe not knowledge, but only commitment to knowledge, etc. We can talk about it during questions if you like. Let's wrap up. So I hope that I've done what I promised to do, which is to show that for our judgments about specific cases to be respectful, we must have knowledge of the facts, of knowledge, proper knowledge of the facts of specific cases. And if I've managed to show you this, and then it can explain why the law seems to be interested in knowledge. The law actually is interested in practical considerations. It is actually interested in respect for persons. But respect has an epistemic condition built into it. And once we understand this, we can also better understand the aversion from naked statistical evidence and algorithmic decision-making in the law, notwithstanding the fact that this aversion might cost us in accuracy. Okay? We are willing to pay sometimes the price in accuracy in order to avoid disrespect. I can conclude by generalizing and noting that I'm interested in, I have been interested today in the law, but as I said, the question is broader. So maybe just to mention, I mentioned, you know, this very odd and unusual decision about grades, students' grades, but it's much more common than that, okay? Profiling decisions. Sentencing all across, when to release the person, etc., etc. It is already done. I've been sent my mailbox today an article about the way in the UK for 20 years they have been using algorithm when they decide whether an offender is dangerous or not, based on the fact that he is male and on the fact that he comes from this or that background, etc., etc. Okay, same thing. Distribution of resources, often also done, partly at least, algorithmically. And we can go outside the political realm. There are philosophers who have been engaging in this question in the context of personal relationships. Another one of Enoch's articles about, and Levi Spector, about statistical resentment. Why do we feel that we cannot resent people on a statistical basis? If I know that, you know, all of you except one are saying bad things on me or behind my back, can I resent each and every one of you based on the variant? So the question is a very broad question, and what I would like to emphasize is that in all those contexts, respect plays some role, but since respect has the nature that it has, as I explained, it might play out differently in different contexts, and we need to examine and see in each particular context how exactly respect plays out, and then what its implications for statistical evidence might be.
Thank you very much.